each person talk for 10 minutes about first why the law is the health care law that was debated in the Supreme Court is constitutional, and then Mr. Shapiro will talk about why he thinks it's not. We'll give them each 5 minutes or so to rebut the other, and then we'll open it up to questions. So, Mike, if you'd kick us off.
Very good. Thank you, Wes, and thank you all for coming. It's kind of fun for me to be at this event, and particularly to play the liberal. As the president or the faculty advisor for the Federalist Society, this isn't a job I thought I was signing up for, but I figured, what the heck, I can...
You can play the traditionalist conservative, that's fine. You know,
well,
defer, defer.
Either sort. I figured this way might be even better because I get to ignore the law, ignore what the Constitution actually says, figure out that the law must mean exactly what I want it to mean, and play the regular liberal.
Oh, I see, that is fun, yes.
Yeah. Doing that the original Constitution would have allowed Congress to do this kind of thing. I don't think James Madison's idea of a federal government would have allowed this, or at least the compromise that Madison had to engage in. What I am arguing is that this is constitutional under the Supreme Court's current doctrine. That what the Supreme Court has said about the Commerce Clause and about the scope of federal power generally, principally the Necessary and Proper Clause in addition to the Commerce Clause itself, makes this law constitutional. The law. The Affordable Care Act, as it's called, was designed to accomplish a couple of purposes. It wanted to expand coverage, health coverage, and it wanted to allow individuals who would have had to pay exorbitant premiums or would have been unable to get health insurance to obtain health insurance. As Congress understood the problem, people were unable to obtain health insurance if, or particularly if, they had pre-existing conditions that made insurance companies unwilling to insure them at a reasonable price. And so what Congress said is that we have this law that requires hospitals to treat patients regardless of their ability to pay. And so if somebody decides not to buy health insurance and doesn't have any other kind of money to cover the health expenditures if they get sick, then the rest of us have to foot that bill. It would be more efficient, Congress said, if we can encourage everybody to get health insurance in the first place.
That justifies a particular government action is it doesn't work if there's no limiting principle that you can articulate to apply for a future case. However you justify the government's action here, there has to be some sort of line, some sort of decision that the court has to make that still leaves that limit in place, because we don't have a general police power like states have. The federal government, again, gets their powers from the Constitution. Oh, and I guess a third thing is that if there's a big national problem or public policy, economic problem, that doesn't give the government even more powers than it otherwise wouldn't have under the Constitution. So the difference here, why this assertion of federal power is unprecedented and unlike anything that's ever been tried, let alone approved by the Supreme Court in the past, is that for the first time in our history, under the guise of regulating interstate commerce, the government is requiring people to engage in economic activity or to conduct a transaction, go into the private marketplace and buy something. This has never been done. In the Wickard case, the wheat farmer, they were regulating, the federal government was regulating how he was to go about his farming. And the dispute was, is this local or is it interstate? And the decision was, well, under the Necessary and Proper Clause in our modern economy, it's sometimes necessary and proper to reach even local economic activity when in the aggregate that has a substantial effect on interstate commerce. Similarly, 70 years later, moving from wheat to weed, the medicinal marijuana case, it wasn't the possession that was the key part of this. It's that Angel Raish and Diane Monson were growing and consuming marijuana. They weren't buying it from dispensaries, they weren't transporting it to Nevada or anything like that, but they were growing and consuming it. And Justice Stevens, writing for the majority, said that, I look at my dictionary and growth and consumption is part of economic activity. So this case is no different than Wickard. Your economic activity in the aggregate has a substantial effect on the illegal interstate market for marijuana.